Good evening, everyone. I welcome you all to the live session of the Ekcel Academy. You all know we are basically conducting a lot of sessions relating to the corporate secretarial, as well as, basically the CS professional, as well as for CS foundation, as well as, basically with respect to all our executive program. So in today's session, basically like I want to specifically talk about one of the important subject which is being prescribed, basically relating to the CS professional program, that is, resolution of corporate disputes, non-compliances and remedies. So this resolution of corporate disputes, non-compliances and remedies is a very important and versatile topic, which necessarily I have to talk about. Because, if I have to talk about it, if you specifically talk about this resolution of corporate disputes, non-compliances and remedies, to the profession of company secretaries, it is really helping a lot. Why I am emphasizing on this? Because when it comes to the professional program, it is really important for us, to look into what exactly, the expectation in the profession of a company secretary as such. That is really important. So if you look at what is the expectation from the profession, that is most important, because the moment you people clear your professional program, you will be having the choice either to take up employment, or you need to start the practice. All that opportunity will throw up, and basically like it is you people who have to choose what you have to be. And you need to necessarily be very well informed about what are the challenges, basically our profession throws upon us. So to be prepared for the challenges the profession throws upon us, it is really important that we should be aware of how exactly, if the crisis situation arises, we should be really prepared of handling it. Of course, compliance is the topmost priority, where we will be, keeping our primary focus on being company secretaries or compliance officers. But when it comes to the other areas within the profession, if I have to talk about, it is really important for us to keep an eye on if in case there is a corporate dispute, if in case if the company is facing any sort of regulatory actions, and if the company is facing any sort of disciplinary actions, which is being taken by the regulatory authorities, how exactly we have to be prepared for that is one of the important thing that we have to always keep in mind. So this particular paper is designed in such a way that the resolution of corporate disputes, non-compliances, it doesn't talk about what are corporate disputes and what are non-compliances. In addition to that, it will specifically give you people the idea relating to what are the remedies available. That is most important, because our job will not stop being company secretaries with just giving ideas or with just identifying corporate disputes or non-compliances. We need to suggest or advise the board members in such a way that there is an exact requirement of giving them a amicable solution to arrive at a corporate dispute, basically to settle the dispute. What are the ways available? Solution plays a very important role. Not giving just or identifying the problem is not our kitty. Not just identification of the problem. In addition to that, we should be giving the solution also. So relief also plays a very important role. So let me talk to you about, basically, some of the important situations where what exactly constitutes a corporate dispute, and what exactly, constitutes relating to what are the various types of regulatory actions that we are going to face. In addition to that, specifically, I will talk about what are the important aspects that we need to necessarily keep in mind while giving solution to the board of directors with respect to various matters arising out of corporate disputes. So I will first take you people through the content, that is most important. This is an introductory class where we are talking about, where I will take you people through the content with brief explanations relating to what exactly is, covered in this particular syllabus. That is most important, because I feel I'm very happy with this particular syllabus, because it is the need of the hour. Because we company secretaries should be having a 360-degree approach relating to how exactly we need to necessarily look into when there is a crisis in an organization. So crisis resolution is very, very important. So resolution of corporate disputes, non-compliances, as well as remedies, this is in your module 6, module 2, paper 6. That is most important. Now, I will just give you people, whenever you open this particular study material, the most important aspect that you have to necessarily look into is this particular part. Okay, what are the acts covered? All that is fine. When you go into the syllabus, what is the expectation out of this particular paper? The expectation from the institute out of this particular paper, please try to understand the objective of the study. That is where you have to start. It is to acquire knowledge of various kinds of corporate disputes, non-compliances under various laws, and their resolution and management. Please, I want to give too much of emphasis on their resolution and management, because just identification is of no use. So we should be prepared with what are the various types of corporate disputes that may arise, because we should be really clear about whether it is actually a dispute or not. If it is a dispute, what are the way out? Whether all disputes has to be taken to the National Company Law Tribunal and fight it out, or there any other ways available? What are the remedies? Because resolution and management is the important aspect that has to be kept in mind, and the company secretary should be aware of. So that is the reason why they have made it very clear that to acquire knowledge of various kinds of corporate disputes and non-compliances under various laws. Please note, our jurisdiction or specialization is not limited only to Companies Act. We need to think beyond company law. Why I'm emphasizing all this? Because if you look into the provisions where in Companies Act 2013, which speaks about the functions of company secretary, one of the important function which is very clearly mentioned over there, I want to call that is the best recognition the company secretaries has, other than talking about 10 lakh, the companies which is having the capital of more than 10 lakh, all that number wise recognition. I will be giving more importance to the provision in Companies Act which talks about the functions of company secretary. One of the important function which is being recognized or which is being provided to the company secretaries is that is they have to make the report to the board of directors on the status of compliance of all applicable laws to the organization. I will take back to section 139 where it talks about the director's responsibility statement under the heading board's report. If you look at in the director's responsibility statement, in which one of the important commitment the board of directors has to provide to its shareholders is that they will ensure that they set a system within the organization to ensure that all the applicable laws to the company are complied with. So all the applicable laws, it is the duty of the board of directors to set a system that will take care of the compliances of all applicable laws. When you come to the corresponding provision which talks about the functions of company secretary, there it says you have to report it to the board of directors on the status of compliance of all applicable laws. Now it is whose responsibility if the board of directors has appointed company secretary? The role of company secretary here is twofolded. The board of directors can take a shelter saying that my duty was only to set a system. System means it is not, I'm talking about the computer systems. It is not a laptop or or a desktop I'm talking about. A system that will take care of the compliance or the compliance management, what I'm talking about. Now the onus, if a company secretary is appointed by virtue of the provision which is being provided in the Companies Act, it will get shifted to the company secretary who is being appointed over there. He has to report it. It is his job to make a report to the board of directors on the status of compliance. At the same time, he has to identify the non-compliances also. See here, why I'm talking about non-compliances? Because it is the duty of company secretary to identify the potential non-compliances. In addition to that, he has to report to the management what are the resolutions available, and he has to manage the non-compliances also. Because the moment you get into this kind of a, the situation where there is a circumstance which will necessarily, there will be, a non-compliance may result in dispute, or a non-compliance may put the company in pressure in such a way where, all the, whatever the concentration they will have over the organization with respect to the management of the over day-to-day affairs of the company, they need to completely concentrate on the litigation. There are a lot of repercussions where the company secretary has to give the assurances to the board members that they will take care of the compliances. That is most important. So this is how the syllabus is framed. So this is what the objective in which we should keep our study. The first and foremost important topic that we need to necessarily keep in mind, the detailed contents. I'm not getting into detailed contents, but if you specifically look into it, this is what the topics are all about. The first important aspect, if you look at, is in the syllabus, it is talking about the shareholders' democracy and rights, the law relating to minority, majority powers and minority protection, and class action suits. Why does this is being given top priority and being included in the syllabus in the first chapter? Please note, what is corporate dispute? Correct? Because this is resolution of corporate disputes, non-compliances and remedies. That is what is the main topic for the discussion. So here, shareholders' democracy plays a very important role. What are the rights the shareholders enjoy to specifically bring out a potential litigation against the management? Please note, generally, corporate dispute may arise between the shareholders, or it will be a battle between the majority shareholders or the minority shareholders, or it will be a battle between the shareholders and the management. Okay, this is how the corporate disputes may arise. Take, for example, generally in case of a large listed public companies, the battle will be generally between the management of the affairs of the company, because the board members will be professional, or basically the promoters, independent directors, all those people will be sitting over there. The shareholders may not be happy with what exactly is being taken care of at the top management level. Shareholders has to always think about the larger picture, where instead of just thinking only about their interest being protected, if they take up the large picture of protecting the interest of the shareholders, if the company performs well, they will also get money. If the company does not performs well, or if some sort of a malpractices is going on within the organization, the shareholders has a very right to identify that, and then they can take that particular matter to the appropriate adjudicatory body, either to the National Company Law Tribunal, or they can seek the help of or make a complaint to the Registrar of Companies for the purpose of inspection or investigation. Like that, there are so many avenues available to the shareholders. Please note, the concept of democracy is very, very important here. Why I'm talking about? Because when it comes to large listed organizations, here if I have to talk about the shareholders' democracy, like how we call ours is the world's biggest democracy, that is India, where the voice of the people has to be heard and voice of the people has to be respected. The same way when it comes to the company, large listed organizations where there is a huge base of shareholders, shareholders' voice has to be recognized. Shareholders' voice has to be identified, voice in the sense like their needs, and then their interest needs to be protected. So it is like by the people, for the people, to the people. The same way by the shareholders, for the shareholders, and to the shareholders. This is all about shareholders democracy. Why I'm talking about all this? Because in the angle of shareholders democracy, what are the important aspects that the Companies Act is talking about? What are the rights the Companies Act provides to the shareholders of the company? If they want to take action against the board of directors of the company, as I'm talking about in case of the listed organizations, what are the important aspects to be taken into consideration? What should be the preparedness of the company secretary? These are some of the important things to be kept in mind. Okay, so now let me take you people through the next important aspects over here. If it comes to the shareholders democracy, it is really important for us to understand what are the important powers the majority shareholders enjoy and how the law is looking at protecting the interest of minority shareholders also. So whether majority prevails or only minority is protected. So if I am a minority shareholder, what are the rights that I'm going to enjoy? So to how can I take action? What and all rights which is being statutorily provided to me as per the provisions of law? So like this, if you necessarily look at, we need to understand the provisions relating to oppression and mismanagement, which is very, very important. And that is the wider spectrum of the corporate disputes, which I have to talk about. Oppression and mismanagement is the topic which is there in Companies Act. The moment you hear the term corporate disputes, it will be majorly arising out of oppression and mismanagement. And like how it was popular in the Western world, that is in the United States of America, they entertained the class action suits also. They have introduced the class action suits in India also, that is through Companies Act 2013. Earlier in 1956 Act, the class action suits were not recognized because there might be large number of deposit holders also who are not covered within the provisions of oppression and mismanagement. Whereas through introduction of class action suits, the jurisdiction of the matter is different because even creditors are involved in oppression and mismanagement. To take an action against the management of the affairs of the company. But when it comes to class action suits, even depositors are included. So I will take you people through all the differentiations when we get into the details later. But to give you people a broad overview of the shareholders' democracy and right, majority of the corporate disputes arises under this angle. This is in the broad picture what I'm talking about when it comes to the listed organizations. In the listed organizations, generally it will be between the shareholders and the management, or the creditors and the management, or it might be the deposit holders and the management. That is how the case will come up. What about in case of small private limited companies? Please note, by virtue of the definition of the private limited company which we are talking about, generally how a private company will be formed. I'm not talking about professionally formed private limited companies. There are various private limited companies which is there in India as on date, which is family run organization. To take some of the important statutory benefits, instead of running it as a proprietary concern or a partnership firm, they would have basically like formed a private limited companies in which the father, brothers, and all these people would be the shareholders, and only those people will be sitting over there as board of directors also. This is the majority number of companies what we have in India, when compared to the professionally run organizations. I should say professionally run organizations are very few in India as per the statistics also, because small organizations will generally have relatives and friends. That is what I want to call. So when it comes to relatives and friends, generally, like take for example, there are 4 directors and then all 4 happens to be brothers and sisters. The tendency of dispute is very high. Why I'm talking about the tendency of dispute here? Because take for example, if 2 brothers are fighting with each other, they might not be in the talking terms also. What happens? There will become a complete deadlock in the management, because the 2 shareholders, and both of them happens to be the board members also, if they are not in talking terms, how they will be able to pass the resolution? Because they will be holding equal shares, and then basically with respect to the board also, there will be a complete deadlock. They will not be able to take any decisions. They will not be able to pass any resolutions. Like that, a complete deadlock may come up in the management. So how to resolve this kind of a deadlock? What are the rights available to the shareholders to release this particular deadlock? During the happening of this particular event, whether statutory authorities can pitch in for the benefit of the stakeholders, because stakeholders is a very broader terminology, whereas shareholders is one aspect of the stakeholders. You all know that. There are various instances. I have to tell a very big hotel chain in Bangalore. The brothers started fighting. I don't want to name because I don't want to take exactly the names of the enterprises. I am just giving you the facts. But the hotel chain was running so successful. There were n number of employees who were working there, but the brothers are disputing with respect to their family property, which has to be divided among them equally. But here, since there is a complete deadlock, which was in the management of the affairs of the company, the matter was referred to the National Company Law Tribunal, which was then newly formed. Until this particular dispute between the brothers are settled, the affairs of the management of the hotel has to run, correct? Because there are so many, employees who were working. There were so many families were dependent on that particular organization. The brothers are fighting. So National Company Law Tribunal ordered that a receiver will be appointed, who was like one of the prominent company secretary was appointed as the receiver, who will take care of the management of the affairs of the company until the dispute is settled. So this is the classic example where the shareholders' interest will also be protected. In addition to that, the stakeholders' interest also will be protected. That is the reason why this resolution of corporate disputes is very, very important, and protecting the interest of minority shareholders, majority shareholders, as well as the stakeholders is one of the important intention of the law. So we being company secretaries, we should be necessarily aware of all this. So let me just go through, take you people through that, because shareholders democracy as well as this corporate disputes is very, very important, because the moment we understand the concept of democracy, we need to get into the law where how the rights of the shareholders are protected. Then in chapter 2, it is really important that we need to get into how the corporate disputes are required to be handled. So if you look at in chapter of the Companies Act, where it talks about the prevention of operation and mismanagement, as I was talking about, how exactly the deadlock may come in, how the differentiation will come in when it comes to the majority and minority, how to release the deadlock in the management of the affairs of the company, what are the important aspects to be taken into consideration, at the time of resolving the corporate disputes, what are the options available to resolve the corporate disputes are available. So if you look at here, one more important activity which I have to take you people through is in lesson 3. Basically, like if you go exactly into the syllabus here, it runs into multiple pages. Why I am definitely basically if you look at the shareholders democracy, the corporate disputes, the class action suits, frauds under Companies Act, regulatory action, totally you have 9 chapters in this particular paper. It might look very simple because when it comes to other subjects, you have some 35-40 chapters which is there. But here it is only 9, but all 9 are, basically are filled with concepts, and then there are a lot of procedures that you have to necessarily learn. And then it is a very important thing because it is one of the important skill sets that the company secretary should be necessarily aware of. Okay, so why I'm emphasizing all this? Because when it comes to the profession of a company secretary, we all think that we have 2 options. Either we will get into practice or we will get into employment. Either in employment or in practice. Of course, employment, you will not get a lot of opportunity to explore because you need to work according to the instructions of your seniors as well as your reporting people. But when it comes to practice, I say that there are 3 important areas where you can think of, as specialization. 3 things: compliance, advisory, and litigation. These are the three important broad areas which is there in the career of a company secretary in practice. Of course, you can choose it in the whole-time company secretary also, that is an employment, but still the most important aspect, as I told you, the choice, the matter of choice will be there majorly, with the practicing company secretaries, because you people will be on your own. So where you can think of, looking at all three, that is basically anything what you feel it is good. That is with respect to three things. Try to remember, it is compliance, advisory, and litigation. Okay. So what do we do in compliance? You know very well, with respect to filing of the form, holding the board meetings, writing minutes, anything that would come under the heading compliance, including your annual filings and all that stuff. Whatever filings that you do, whatever appearances, basically with respect to taking the approvals from the statutory authorities and all that. But when it comes to advisory, there you will be playing a very good role, where you will be advising the board of directors, you will be writing an opinion with respect to how the whole structuring has to happen. Please note, there are various opportunity for company secretaries where you can tie up with the law firms, you can tie up with the chartered accountant firms. Like, there are multiple startups, as well as there are so many huge organizations. They need your support with respect to advisory relating to structuring of the organization itself. You need to advise them whether they want to have a private limited company or they want to start a limited liability partnership. What is the funding that they are looking at, where the fund is coming in, whether we need to issue equity shares or we need to issue preference shares. Like that, there are a lot of questions, who has to be appointed, where the office has to be, what is the difference between executive director and non-executive director, how to strategically appoint a managing director or whole-time director. Because please keep in mind that when it comes to non-compliances, the regulatory authorities levy penalty on the officers who is in default also. So who is officer who is in default? That is most important. Why I'm specifying this? Because an officer who is in default is something where you can define. It is not like, by virtue of the law, an officer who is in default will be specifically arrived at. Please note, you can plan the organization structure in such a way that there are a person specifically for the purpose of Companies Act. In the event of default, he should be considered as officer who is in default, so that there is lesser penalty on the organization, where all the directors will not be booked for that particular offense. On every director, penalty will not be levied. Only on one person, who is the executive chief, who is entirely responsible for compliance, will necessarily take care of. So who has to advise this? It is the role of company secretary, because we are experts in corporate law and in Companies Act. So please keep this compliance, okay, advisory, and litigation. These are the three important aspects, or the avenue what is there to the the specific the role the company secretary plays. Why I'm emphasizing this, please keep in mind, because this resolution of corporate disputes, the paper itself is included to give you people a very good opportunity. The moment you complete the course, you should have this thoughts in your mind, that what exactly is there very closer to your mind. So now coming to why I'm telling this all, because when it comes to compliance, it is straightforward. Advisory is also straightforward with respect to, you should think really analytical, and what is the requirement of each client you should necessarily understand, and then you need to give your advice accordingly. When it comes to litigation, you can have the choice whether I need to get into the litigation part or not. Please note, under litigation also, you have two important aspects. One is only the approval services. Other one is the core, basically with respect to the orders, or, basically like it is the prime litigation, what I'm talking about. Please note there are so many aspects where for the approval we need to go to the National Company Law Tribunal, like it might be M&A, or it might be compounding, the huge compounding related offenses, or it might be the shifting, or it might be, there are so many aspects where you need to take the approval from the regulatory authorities. That is something one-sided where you need to follow the procedure of law. There is no element of litigation over there. But still, basically this is relating to the appearance or approval services before the National Company Law Tribunal. But here, when it comes to the actual litigation where there might be operation and mismanagement, fraud or something like that, where either I need to appear before the National Company Law Tribunal, or I need to appear before some of the important statutory authorities. So when you have to keep this aspect in your mind, you have the choice again. Please note this one, operation and mismanagement, and then the fraud related cases, whatever it might be, was always there in the lawyer's domain, because it was to be in the High Court. In High Court, only advocates are allowed to appear. But now the opportunity has come up where even practicing company secretaries are allowed to appear. Please note one of the important chapter, which we need to talk about here, where we have, the opportunity, what are the important forums where the company secretaries has opportunity to appear before. So please try to understand, this is very, very important. That is the reason why they have included it in the syllabus. Okay, so this is what I was talking about, the shareholders democracy or corporate disputes, whatever it might be, because for you people to sail through in this profession, please make an informed choice. Which one is very close to your heart? Get yourself interned by the respective people who are practicing or who are specializing in advisory or compliance or litigation, whatever close to your heart. And then you can, basically after getting trained, till you feel confident, you can either get into your own, become a full-time company secretary or practicing company secretary. But now I know what is the target is completing the exams and then, to become the company secretary. So what should be our target, or how we should start our studies? Because now I gave you the broad picture which relating to the importance of this particular paper. So after talking about the importance of the paper, it is our role to necessarily help you people with how to clear this particular paper. Otherwise, why the academy should be, and then why we teachers should be to this particular chapter or this particular syllabus. So to help you people to, basically with respect to, approach, how exactly it should be when it comes to, clearing the exams, that is where our role will come in. So how exactly we need to get into is, we need to learn the entire subject, because there is only 9 chapters. I will always tell to my students that there is choice only in the exam, because the question paper will be set for roughly 150 marks, where you have to write only for 100 marks. So you have choice there, but no choice for studies. Please don't take choice at all while studying. You need to cover the entire syllabus 100%, so that you are prepared for the examination in a very good fashion. So that is most important. Okay, so please try to understand, that is how it is. So let me come back to what we were discussing. So shareholders democracy, I have given you people a brief introduction about why it is most important, and then I have given the introduction about the corporate disputes also, and the class action suits, to some extent. Why I'm talking about all this, because if you look at corporate disputes, it is operation and mismanagement is what majorly we will discuss about. But when it comes to class action suits, it is really, under various acts, there are class action suits. It is not only under Companies Act. You have class actions under labor law. We have class actions under Consumer Protection Act. We have class actions under National Green Tribunal. Even public interest litigations are also class action suits. Like that, briefly, what is very close to the role of company secretary is being elaborated. Remaining things they have given it briefly. So we need to understand both, please note, substantive law as well as procedural law. Very, very important. Why? Because we being professionals, what is expected is expert knowledge. okay, from the institute. So expert knowledge means what? We should know both substantive provisions of law as well as procedures. Most important. What is the remedy? To arrive at that particular remedy or to achieve that particular remedy, what are the steps which is required to be followed? If it is operation and mismanagement, a client is sitting in front of you, how exactly you need to approach this particular problem, and what are the remedies, which section I need to file a case, which court I need to file the case, whether civil court is having the jurisdiction, what is the format in which I need to write the petition, what should be the content of the petition. To getting into this kind of details, we should be aware of both substantive provisions of law, that is the enabling or the subject matter, okay, as well as the procedure. Correct? I will give you a very simple example between these two. The difference between substantive provisions of law and procedural. I will refer to section 185 of Companies Act 2013, where if I can, it is relating to lending loans. Correct? So if a company wants to give loan to anyone, the first section that it needs to check is section 185. Whether that person is eligible to receive the loan or not. Correct? So if you identify whether he is eligible or not, you will refer section 185. So once you understand if he is eligible, then only you will look into the procedure to give loan, which resolution has to be passed, board resolution has to be passed, shareholders resolution has to be passed or not. If the moment 185 says it is prohibited, loan cannot be given, is there a possibility to look into procedure? No. By following the procedure, I will not be able to achieve that. So please keep in mind, substantive provisions of law will be enabling in the sense like whether allowed or not, it will talk about. It will say Indian Companies Act provides for incorporation of private limited companies. So it says minimum 2 directors should be there, minimum 2 shareholders should be there, all the conditions are kept. That is substantive provisions of law. What is the procedure to be followed? Procure the digital signature, file the run application, that is register unique name, and then you file the the web-based forms for incorporation, Spice Plus, Agile, and all that, and then finally you will get the certificate of incorporation. This is what is the procedural. Okay, so here we need to concentrate on both substantive provisions of law as well as procedures. So corporate disputes. So operation and mismanagement we just now discussed. In the sense, briefly, in today's class, since it is only, I'm talking about only introduction, I will not get into too much of details to the concepts. In the later classes, I will introduce you people to each subject in detail, each chapter in detail. So if you look at this particular provision here, one of the important thing that you have to keep in mind is the fraud under Companies Act 2013 as well as Indian Penal Code. One of the important thing which brings in a clash between the shareholders and the board of directors, or it will bring the company to a virtual, basically with respect to, a standstill or a stop, whatever it might be, it is the fraud. There are a lot of instances which has come in Companies Act 2013, where the penal consequences, what they have to, basically with respect to face, the reference is being drawn to the concept of fraud. Section 447 is the section which specifically talks about fraud. Why I'm telling this in particular? Because after operation and mismanagement, the most widely spoken in the newspapers or in the commercial, in the sense like Economic Times or whatever the corporate newspapers which I have to necessarily call, you will get the news relating to frauds. Like it might be starting from Harshad Mehta, or it might be the Ramalinga Raju of Satyam, like that. There are various cases, and even today there are a lot of cheating cases. They will take the money, run away. That's why they're tightening the deposit related laws, where the jewelry shops used to collect the deposits and run away, and then the chit funds used to take the deposits and run away. Keeping all that in mind, this fraud related provisions are incorporated under Companies Act 2013. very wisely. Why I'm talking about this? Because punishment has to be provided. Please note, it not only defines what does the term fraud means, in addition to that, it defines what is the penalty which is required to be paid. And necessarily, like, if a person has committed the action of fraud, what exactly broadly it would come under the definition of fraud? Because here the term fraud is there in Companies Act as well as under our Indian Penal Code. So we should be necessarily aware of what is the primary distinction between the fraud under CA 2013 versus IPC. Please note, it is not just IPC. If I have to take you people through the syllabus in detail, in addition to Indian Penal Code, you have various other enactments which is talking about fraud. One of the important act is the Indian Contract Act. In the Contract Act also, you will find the definition of the fraud. So this analysis is required to be made. How exactly it is different, where the action has to be taken, the definition has to be taken through this. So very important, please keep this in mind, because the fraud under Companies Act 2013 versus Indian Penal Code, this differentiation and what is the punishment for fraud, all that we need to necessarily understand from here. Okay, so like that, basically, like if you look at in the shareholders democracy, the rule, the principle of non-interference, and then the rule of Foss versus Harbottle, the exception to the rule, like that in detail we will take you people. And when it comes to the corporate disputes, it is operation and mismanagement is what is the highlight, okay, which we need to get into the details, including the procedures in detail, punishment. In addition to operation and mismanagement, there are other important corporate dispute areas also, like transfer and transmission of securities, the punishment for personation, the refusal to registration or appeal against refusal, in the sense this is with respect to transfer and transmission of shares, rectification of register of members, etc. Okay, so these are certain important aspects that has to be necessarily kept in mind. And the class action suits, who can file the class action suits? What are the types of class action suits? I told you in Companies Act 2013, class of action suits is there. In addition to that, you have under Consumer Protection Act, under environmental laws, under labor laws also, there are various class action suits which can be necessarily looked into. So here I was like, we were discussing I was just giving you, I was introducing you people to the terminology of fraud. And then I had given the reference to 447. So here we need to start. What is the meaning and definition of the fraud? Most important, because there are whistleblower policies in the organization. There are multiple things which has to be kept in mind. So why we need to specify on which type of frauds are punishable under 447, where action can be taken under 447. That is most important topic of discussion here. What is the difference between a compoundable offense and non-compoundable offense? Very, very important. There are two things: cognizable, non-cognizable. Compoundable, non-compoundable. Civil, criminal. Correct? There are various types of offenses. Please note, first let me start with the bottom, basically with respect to what is the difference between a civil and criminal. Please note, if the terminology used within the section of Companies Act 2013 or any law for that matter, if they use the terminology be punishable with fine, if they use the terminology, because if you get into any of the subsections, they will say any person who has violated the provisions of this section shall be punishable with a fine which shall not exceed 1 lakh or imprisonment, like that it will be mentioned. The moment they use the term punishable, it will become criminal. If they use the terminology, they will be subject to penalty. Generally, this is the terminology used. If subject to penalty, then it is civil in nature. Okay, please note, majority of the things which I see in Companies Act 2013 is the terminology what they have used is punishable. But it says punishable with fine or imprisonment or both, they say. Or in sometimes they say and both. Or in some circumstances, they say it is only fine. Okay, so this is the background, what I'm talking about. If it is civil, then it is governed by IPC. If it is criminal, it is governed by basically like not CPC, Civil Procedure Code. If it is criminal, it is governed by CRPC, that is Code of Criminal Procedure. So this is the difference between civil and criminal. Cognizable and non-cognizable. Before going to that, I will go to compoundable and non-compoundable. Please note, what are compoundable offenses? Please note, compoundable offenses are the one where they are punishable with fine only, or with fine or imprisonment. Okay, or both. If they use and imprisonment, they are not compoundable. That is the point of differentiation. Compoundable means very simple. You can pay penalty, compromise it with the regulatory authority and come out. You have not paid you have not conducted the annual general meeting. That is an offense. You go plead it before the respective regulatory authority. They say this is the penalty you have to pay because you have done the non-compliance. You pay the penalty, come out. That kind of things are called compoundable, where it makes the life of the company secretary simple. So you will get an immunity for the same offense. You are not going to be prosecuted again. Non-compoundable offenses are the one which are serious in nature, where the punishment for it is fine and imprisonment or only imprisonment. They are not compoundable. Okay, coming to cognizable. Cognizable offenses are basically like non-bailable offenses. Non-cognizable offenses are bailable offenses. Please note, generally all compoundable offenses are non-cognizable offenses and all non-compoundable offenses are cognizable offenses, because the degree of the issue is high. Okay, that is how I can cross-link and then differentiate. All cognizable offenses are non-compoundable, whereas all non-cognizable offenses are compoundable. Why? Because cognizable offenses are so serious that they are not at all bailable. They will not be released on bail, like fraud or something like that. Non-cognizable offenses are bailable in nature because they are petty offenses where the seriousness or the degree of it is not very high. So if a person has to be arrested, which is out of a non-cognizable offense, arrest warrant is mandatory. Whereas in case of a non-cognizable offense, which is called non-bailable offenses, for which if a person has to be arrested, warrant is not necessary. Warrant is not mandatory. Okay, this is what the differentiation which I can talk about with respect to the types of offenses which is there under various corporate law scenario. So we need to be very much aware of it, because following on the chapters, that is fraud under Companies Act or Indian Penal Code or whatever it might be, we need to necessarily keep all this in mind. And there are other important aspects under Indian Penal Code also, like criminal breach of trust, punishment for criminal breach of trust, and the cheating, because I just now told you, there are a lot of companies which cheats its clients or customers, the fraudulent deeds and all that. Basically we need to necessarily get into the forgery and even the fraud under the SEBI regulations also we need to get into. Not just IPC, this fraud is necessarily discussed under various other enactments also. This is relating to the litigation part what we were into. But when it comes to lesson 5, where we will come into the lot of regulatory actions. Nowadays, the Ministry of Corporate Affairs, after this V3, the new, the version of the MCA, where they're phasing it out, where it is so evident that they want to give too much of importance to the regulatory actions. Please note that one important slogan, or the whatever I want to write it here, fear leads compliance. Please keep this in mind. How many of us are really interested in doing the compliance with the letter and spirit, keeping in mind the objectives of the law and all that stuff? I wear helmet because there is a cop who is waiting in the circle that he will levy a penalty on me. If there was no police or traffic police who was watching at me, because I'm not at all interested to wear a full cap helmet for the shorter distances, because it is really irritating. Of course, the law is made to keep in mind that, your skull needs to be protected. If an accident happens, you need to be protected. Recently, I saw a news in the Kannada news channels that a film actor passed away because in a bike accident, he was not wearing the helmet. This is true. But still, 99.99% of us are wearing helmet because there is a person who is going to catch hold of us and then he is going to levy penalty. So fear of penalty that we have to pay leads us to compliance. The fear of regulatory action. What is regulatory action? Regulatory action will be taken by the regulatory authority. In our case, the regulatory authority is Ministry of Corporate Affairs. Listed company, you have SEBI, that is Securities and Exchange Board of India. If you are an insurance company, it is IRDA. And then if you are a banking company, then you are Reserve Bank of India. All these people are there to catch hold of your neck if you are not doing the compliance. So it is very, very important to keep this in mind, that the regulatory authorities will take an action. So this fear will lead compliance. So when the regulatory authorities come forward, we need to understand what is the regulatory framework. How exactly the hierarchy of the officers are there in the Ministry of Corporate Affairs. Who can take action against you? If they come forward to take an action, what are the grounds under which they can take an action? How a company secretary has to be prepared to face the regulatory action, because there might be inspection, inquiry, and investigation. Very, very important. We need to understand the differentiation also between these three. I have made separate videos. Please go, in our channel, in the Ekcel Academy channel itself, you will find the basic differentiation of inspection, inquiry, and investigation. You will find it under the, basically like short videos I have made under each topic in this particular chapter. You can go to that, basically where you will find all the differentiation between these three. What is the purpose of conducting the inspection? How the investigation is going to happen? During the process of investigation, what are the important steps which will be taken? Can the inspection or investigation lead to winding up of the affairs of the company? Like that, there are various aspects that we need to get into that during the process. If a regulatory action authority is taking action against that, how we need to keep an eye on that, and how a company secretary has to be prepared to face that. I will just tell you that this is at the end of the chapter. You will necessarily find, please note, not only in the Companies Act, they are giving under SEBI, they are giving under Companies Act, they are giving under Competition Law, the Factories Act, the Goods and Services Act, the GST, the Income Tax Act, the Code of Criminal Procedure. Every act they have covered, because regulatory action may come up not only by the Ministry of Corporate Affairs, it can come from any other regulatory authorities also. So you have a very interesting topic here also, the CBI investigation, the Enforcement Directorate investigation, the cyber crimes, all the aspects we need to necessarily look into. And then here we will be necessarily talking about what is the role of company secretary in facing this particular issues. Next topic is adjudication, prosecution, offenses, and penalties. I have already, given you people the hint on how the offenses are classified. Offenses may be of three types. civil, criminal, cognizable, non-cognizable, compoundable, non-compoundable. That is what is the broad categorization of offenses. What is adjudication? Please note, you will call it adjudication of penalties. In the previous chapter, we would have discussed what are the types of regulatory actions can be taken. During the process of regulatory action, what are the important activities which will take place is investigation, inspection, and inquiry. If the regulatory authority conducts an inspection or inquiry, they will come to know potential non-compliances. So when they get to know identify the potential non-compliances, they can adjudicate us. Adjudicate means they can ask us to pay the penalty by sending a notice. If it is of very serious nature, say there is a fraud or something like that, then they can initiate prosecution. What is prosecution? It is the terminology used in criminal law. Adjudication is the terminology used generally in civil law, where if I have to ask someone to pay the penalty, there is a procedure which is required to be followed. I need to send a show cause notice and all that stuff. And at the same time, if I have to arrest a person or if I have to file a charge sheet against him, then it is necessarily called as prosecution. That is the terminology which is used, where if a director has to be prosecuted, first arrest warrant, take him to the custody, file charge sheet, and that is the procedure, prosecution. For the offenses, correct? And offenses, if it is generally civil in nature, then it will end up in adjudication. If it is criminal in nature, then it will end up in prosecution. This is what the clear-cut differentiation you should have. And then what are the penalties? What are the kinds of penalties under Companies Act, under SEBI, and various other legislations we will get into in this particular chapter. Okay, so case studies, analysis, everything will be there. It looks simple, but it is not that easy. Then comes the relief and remedies. Most important, because it is the role of the company secretary to suggest what is the relief and remedy available. Like you have the compounding. Okay, if you identify that there is a prosecution which is going to come up, and then you already have identified the type of offense, then easily you can go ahead and compound that particular offense. And at the same time, if you are not able to compound it, and if that is a kind of litigation which is being coming in, then you can go for mediation and conciliation. Or you can go for settlement proceedings as per SEBI. Like that, mediation and conciliation is also one of the important opportunity available. What is the role of mediator? How exactly the mediation has to happen? And what are the types of compounding? If you're not happy with the adjudicating authorities taking action against you, then you have another right, basically with respect to, coming out of the regulatory action is you can prefer an appeal. Correct. First is compounding. Second one is mediation and conciliation and settlement. And the third important activity is appeal. Correct. These are the three things that if you're aggrieved by the orders of the lower authorities, you can always prefer an appeal. So what are the appeal provisions under Companies Act, SEBI, Foreign Exchange Management Act, and all that needs to be discussed. So like that, if you go, next comes the crisis management. Again, management related topic here. What are the types of crisis? During the crisis situation, how to handle? Is there any possibility available? If regulatory action is being taken, if they are asking us to pay huge penalty, how we can be prepared to pay that penalty? Is there any insurance facility available? Please note, a wonderful insurance product has come in. Professional indemnity insurance and D&O policy. Professional indemnity insurance is generally protects the interest of the practicing professionals. Like if a client wants to sue us for some damages, then we can claim the insurance policy and then make the payment. Not very popular in India though. But the director and officers liability insurance or D&O policy is becoming very, very popular among the corporates nowadays. Why I'm specifying this? Because the directors and officers liability insurance is one such activity where it protects the interest of the what is that, basically the directors or the officers who is in default, and then the officers liability insurance is one of the important thing which is being taken. That is D&O insurance, which is becoming very popular nowadays. The last lesson is relating to misrepresentation malpractices. Why? Because there are a lot of malpractices and misrepresentations that might come up in the, basically with respect to the career as a company secretary, or even in the corporate world. If you look at what is the regulatory framework, what is the difference between civil trial and criminal trial? Very, very important. We should be aware, because we have to go through this procedure just in case if we need to face any regulatory action. So the difference between Indian Penal Code and Code of Civil Procedure and Code of Criminal Procedure, how the trial happens in case of civil law and how the trial happens in case of criminal law. What are the procedures, where exactly the company secretaries need to be very careful of, because we should be aware. Because suddenly if they say, you company secretary, go and appear before the respective tribunal and then represent us. You are on the first day of the job and then don't know anything. The manners also, that how exactly I need to appear before a regulatory authority. So to brief you people regarding how the trial process, how the proceedings, trial is nothing but proceedings. Okay, how the proceedings are going to happen, we need to be very thorough about it. In criminal law, how it happens, and in civil law, how it happens. So very, very important difference between the trial procedure under Code of Civil Procedure and the Code of Criminal Procedure. With this, the overview of the syllabus ends. It is only 9 chapters, but still the depth of it is very high. So when we get on to the syllabus in detail, one by one chapter, I will take you through people with respect to the concept, because my way of teaching is always giving you people conceptual clarity. If you people are aware of concepts, then easily you can understand the procedures. So I want to teach you people fishing, not just giving you the fish right away. Basically with respect to giving you only the bookish knowledge is not at all the intention. So the objective of the study is making you people conceptually clear of what exactly all these terminologies are all about. Okay, so hope you people understood the importance of this particular subject. In the given time, I am able to show justice with respect to what exactly the syllabus is all about and give you people a nice introduction about what exactly the syllabus comprises of. So we can get into the details and then the detailed content, the analysis in the forthcoming classes. What is the study pattern here will be, the moment one chapter is over, we will get into the previous question papers, and then we will do the revision of how the questions will come in the exams. And then we will try to analyze, how the presentation should be, what is the expectation of the institute. We will get into the guideline answers also. And then for how many marks, how much answer you have to write and how appropriate your answer should be, what should be the language that you should use, all this kind of discussions that we will make after each chapter. And then finally our objective is to attempt the examination confidently and come out of the examination with flying colors. Okay, thank you very much. Let us meet in the next session.